Welcome to this week's segment of Ask an Attorney. I am Peter Morgan, and this segment is being brought to you by Morgan Law. The topic for this time will be separate incorporation or setting up an entity for purposes of real estate investment, and that is something that I frequently run into as part of my residential closing practice. There are some definite advantages to setting up a separate, what we sometimes call a holding company, which becomes the actual owner of the property, and I'll be talking briefly about those today. So to start off, when we're talking about a separate holding company, most commonly I am using what's called a limited liability company, an LLC. That is a little bit newer form of corporate entity, but has a lot of the same sort of structure as a more traditional sort of corporation. Their LLCs are fairly easy to set up and maintain, which is the reason I like to use them, but they have the same sort of general legal protections that a more traditional corporation would have. So is it a good idea to put your investment property in an LLC or even to acquire one in the name of the LLC? It can be. One thing to bear in mind is, of course, that if you're going to acquire title to an investment property in the name of the LLC, that is a much simpler proposition if it's going to be a cash transaction. If it is going to be a finance transaction, then the lender is going to require that the corporate entity have some type of actual credit history or other basis of creditworthiness, which can be sort of complicated to establish. So that may not be the easiest route to go as far as the acquisition part of it is concerned. But you do have the option, of course, of after you acquire a piece of property in your own name, then transferring it to a separate LLC, which is actually fairly common. The only thing to think about when you are making that decision or to bear in mind is if you did acquire a piece of property in a finance transaction in your own name, there will be a mortgage or deed of trust that will have what's called a due on sale clause in it, and that specifically prohibits transferring the property or an interest in the property to a third party without basically paying off the loan, or they can accelerate the note, in other words, if you transfer a property interest. It could be grounds for foreclosure. As a practical matter, lenders don't necessarily blow the whistle on everybody that ever transfers a property from their own name as borrower to an LLC, but it is something to take into consideration, and I always caution my clients about that risk and try and work through that with them before we make that final decision to transfer. If, of course, you used cash to acquire the transaction, you're free to transfer it over to an LLC anytime you want to. So the reason you would do so, primarily the advantage to using a separate corporate entity to hold property is for liability reasons. If you hold property in your own name, then technically if somebody were to, let's say, have a claim arising from an injury that was sustained while they were on that property, homeowner liability. If that's in your own individual name and that individual gets a judgment arising from that liability, then that judgment could then be enforced against other assets that you personally own. It's a little bit more complicated than that if you're married, but that is always a concern, is that you want to avoid personal liability for something like an investment property. And so having the actual ownership in the LLC's name means that any judgment for liability is actually going to be against the LLC and not against you personally, which is definitely preferable. You should have insurance in any event to cover it. Insurance should always be your first line of defense, but if for some reason insurance is not sufficient or not available, you would much rather have that liability just tied to that one LLC rather than following you around personally. Now, in addition to liability, the other common consideration with using a separate corporate entity to hold property would be for tax reasons. I don't offer tax advice or consultation as part of my practice, so I always encourage my clients to talk to a qualified tax professional to make sure that any type of separate holding company is going to be beneficial to them from a tax standpoint, at least not harmful. So you always need to look at really both considerations, both liability and taxes, when you're thinking about having a separate company to hold investment real estate. So to sort of recap, I do think that using a separate company to hold real property or acquire real property can have definitely some positive advantages. You just need to be mindful that if you do acquire a piece of property in your own name using a mortgage, that there are some additional considerations, and obviously talk to an attorney about those considerations before you make any transfers. In a future segment, I also want to address the issue of corporate versus individual liability. I've recommended an LLC for liability reasons, but there's some further complications even in that part that we can talk about in a future segment. So I hope you enjoyed this discussion this week, and I look forward to seeing you again in a future segment.